The Honourable Parliamentary Secretary to the Minister of Canadian Heritage.
Thank you, Mr. Speaker, and I'm very glad to speak here in support of Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts. And I just want to first start off by acknowledging that we're gathered here on the traditional lands of the Algonquin people, and to kind of give you a sense of my involvement with the criminal justice system. I worked as a youth worker, ran a youth service agency several years ago, and in fact I came across a number of young people who have had interactions with the law, with the criminal justice system, and often found it quite frustrating, the manner in which the young people were looked at in silos in respect to the charges that were in front of them and their involvement with the criminal justice system. I also, as a lawyer, I practiced in this area very briefly, and I have over the years worked with a number of organizations that work with youth, especially involved with the criminal justice system. And just last Christmas, I along with the Toronto Breakfast Clubs and the Second Chance Scholarship Foundation, was at the Roy McMurtry Centre for Young Offenders, and had a really good afternoon meeting a number of young people who were involved in the criminal justice system and who were serving time. And since my election as MP, I have visited a number of institutions across Ontario, including detention centres and penitentiaries. What's clear, Mr. Speaker, to me from my engagement with the criminal justice system is that it's not fully working. There's a lot that we need to do to change it and to improve it. And I believe C-75 does address a number of important issues. First and foremost, the issues of delay, the issue of safety in terms of how our communities are, and of course the massive overrepresentation of certain groups within the system. And I'll note that the Office of the Correctional Investigator, whose reports are actually quite insightful, offer some really drastic numbers, and they reflect what I believe are structural issues within our system that oftentimes render particular groups overly represented within the criminal justice system. And just as an example, 40% of women in penitentiaries are Indigenous women. That is a gross overrepresentation in relation to their population in Canada. Similarly, young black men represent 8% of roughly 8% of those serving time in penitentiaries, and similarly, Indigenous men are just hovering around the 30% mark. And we know in relation to their numbers, they're much more pronounced and disproportionate in terms of the representation. And one can ask ourselves why this is so. And I think I've been involved in my current role as Parliamentary Secretary to the Minister of Heritage in undertaking some discussions and some engagements on anti-racism. And it's very clear, Mr. Speaker, that there are underlying structural and systemic issues within our criminal justice system that does have some very specific outcomes. This is on top of issues of poverty, issues of disenfranchisement, the issues of lack of housing, and a whole host of other social determinants. But complicated with that is a system that in many ways is deeply problematic in terms of the manner in which it treats certain groups of people. And I believe that C-75 goes in some lengths to address these issues, probably not to the full extent it may be required, but certainly goes a distance in addressing some of these structural issues. And I want to kind of maybe talk about a few of them this afternoon. First, Mr. Speaker, the C-75 changes the way our system deals with administration of justice offenses. And I can't tell you the number of times I've worked with young people who have been charged with an offense. Oftentimes the evidence against that individual is quite weak, but unfortunately because of the terms of bail, the terms of release, they often find themselves back in detention, back in jail, back facing additional charges. And I think it's deeply frustrating when we see that. And I can tell you one of the immigration cases that came to my office involved a young man, 40 years old. He came to Canada when he was 8, and he was involved with the child welfare system. I believe his first charge was when he was about 13 as a young offender, and within a year he was found not guilty of those charges, but within a year he was charged and convicted of an offense of breach of condition, namely that he did not appear in court. Now we're talking about a 14-year-old young man who, by all measure, had many obstacles in his life, including the fact that he was separated from his parents. He was growing up in the child welfare system, and this young man who ended up going to missing court, who was convicted for the first time, and then I saw his record, and over again, it was not the issues of the actual crime. It is administrative justice offenses, administration of justice offenses that he was convicted of, and which really tells you, Mr. Speaker, that our system is not working. And we can look across the country of many young men and women who are serving time because the way that we have set up our system is one which is very punitive and which is very restrictive. And while it's essential to ensure public safety, I do think we can do this by making sure that the terms of release are proportionate and are reasonable and are acceptable to all the parties. And I think that's something that I see very often. I can tell you, when I work with young people, one of the standard terms of release that I saw in bail is non-attendance of, if an incident took place at school or nearby a school, oftentimes a condition that a young person does not attend to that school or go near the school. Now, how is it fair that you have a 15-year-old in grade 10 who is having some difficulties in life, who is restricted from going to that school? I mean, that the change of schools, change of circumstance will obviously extenuate the challenges that a young person has in life, and oftentimes will lead towards greater involvement with the criminal justice system. Sadly, Mr. Speaker, I don't have time. I was thinking I have more time to speak on this in a bit more detail, but I can tell you that this bill is very important. This does go part ways in addressing some of the systemic issues that we saw, we see in the criminal justice system, and particularly with respect to the racialization of incarceration in Canada and many parts of the world, but particularly in Canada, as documented by the Office of the Correctional Investigator and others who have pointed to highly polarizing numbers that speak to systemic issues within our criminal justice system. In summary, Mr. Speaker, I would I'd just like to say that the issues addressed in this bill, namely the delay aspect, making sure the delays are limited by eliminating undue processes, are important, as well as the overrepresentation that I discussed. as well as making sure that issues such as intimate partner violence are addressed. I believe that this is a very important bill that warrants the support of all of our colleagues here and across the aisle as well. Thank you, Mr. Speaker.